Yeah, okay, great. Sorry. My name's Nima Maleki. I work at Velton, Zegelman, PC. We specialize in a lot of corporate securities work, a little bit of mid-market M&A as well. Primarily now our practice focuses on blockchain, and we have a hyper-focus on ICOs and then also exchanges as well. And with that being said, my personal background, since I started an attorney, I started working at a private equity firm and transitioned a little bit to M&A from there. And then a serendipitous transaction kind of led me to this, and here I am.
Good afternoon. My name is Felix Shipkevich. I'm an attorney with commodities and payments background. I've been in the payments space for about 15 years. Prior to founding my firm, I was a general counsel of a futures commissioned merchant and a swap dealer with the CFTC, registered with the CFTC and the NFA, and look forward to this presentation.
Good afternoon, folks. My name is Seth Goettelman. I'm an attorney with Gould and Ratner. I specialize in corporate and securities work. I represent hedge funds and formation investments and startups.
Hi, I'm Jason Gottlieb from Morrison, Cohen in New York. I represent, I'm a general litigator, regulatory enforcement lawyer, and I'm currently representing publicly anyway some of the first folks charged by the SEC's new cyber unit for an alleged wrongful ICO. And I've also got some other non-public ICO and blockchain representations as well. So we're seeing what the SEC and CFTC are talking about on the regulatory enforcement from the front lines.
And hello, everybody. Good afternoon. As you could probably guess, I'm also a securities lawyer. You could find out more about me at finlawyer.com. I'm a prior 20-year securities regulator at New York Attorney General's Office, a Securities Bureau, New York Stock Exchange, a Division of Enforcement, and most recently at FINRA. I started my own practice, which is based in New York in 2015, and I represent individuals under investigation by the SEC, FINRA, other regulators, in addition to providing advice to people who don't want to be under investigation.
Yes, we have a great deal of expertise here and quite a broad range of stuff to talk about. So we're going to go straight into the subject of ICOs and also SDOs. And we've had a lot of interesting discussion in the earlier panel discussions about the dynamics of conducting these and a lot of the regulatory issues involved. And stepping back a little bit, there is, in the bigger picture, I think a great deal of uncertainty that everyone is aware of. You have multiple regulators involved, the SEC and CFTC. You have the CFTC, a great proponent of blockchain, and a very broad range of opinions among the various SEC commissioners. And at the same time, the SEC and CFTC cooperating, but no one is quite sure exactly what that will look like. And it creates a great deal of uncertainty for ICOs and utility tokens in general. And at the same time, those are very broad sectors. There are different situations that have to be addressed. And I think that maybe our panel can talk about the great diversity of situations and how they should be looked at.
Sure. I'll jump in. Anyone here of Operation Crypto Suite? Yeah? So, I mean, I think just to kind of piggyback off what you were saying, we're starting to see a concerted effort by regulators now. I'm speaking from a lack of personal experience with this, but I assume regulators are speaking amongst themselves on how to handle all of this as well. And then you start to look abroad as well, because that's part of this discussion, right? And you actually see in the UK where they formed a coalition to actually deal with all of this. Kind of the whole square peg, round hole situation also is a result of, how is this thing classified, and who's going to regulate it? And at the moment, like you just said, we have multiple regulators trying to come into this space and kind of deal with this thing head on, but we don't really have any clear guidance on it. And so anytime a client comes up to me, they're like, you know, who do I need to look to? What rules do I need to look to? I just tell them all of them. And let's go ahead and tackle each issue on a case-by-case basis. And if that results in you spending a little bit more money just to be safe, then so be it.
I think so far we've seen that the CFTC and SEC have not sought new statutory guidance. In fact, they went to Congress and specifically said we do not need new statutory guidance at this time. As a result, what they're doing is enforcing. They're trying to tell people what the rules are by enforcing and telling people what they're not allowed to do. And unfortunately, as we heard from a prior panel, that leaves a lot of gray area as to what you can do. What we've seen is a few different striations of ICOs that the SEC in particular is looking to enforce against. We all know the last couple of years has brought a ton of ICOs. There are a ton of coins out there. We heard that some of these are, let's call them in 3 levels. The first level is what we can call absolute frauds. Somebody says, give me money, I'm going to give you this awesome security token. You give them the money, they say, haha, sucker, see ya. That's a fraud, okay? The SEC is going after that, and nobody has any objection to the SEC going after that because those people should get out of the industry. There's another level down, what we'll call the second level, that the SEC is also going after, which is ICOs that actually do deliver tokens, so people are getting a token for their money, but they're being sold on what the SEC considers to be misrepresentations or omissions in the offering documents, saying, well, we think you're going to make 1,000% from this, and obviously those are things that you probably should not be saying unless you can back it up. That's a second tier. But there's a third tier under that. The chair of the SEC, Jay Clayton, has said that he hasn't seen an ICO yet that wasn't a security offering, and most of them have been unregistered securities offerings, which is a violation under the securities laws. So this third tier, all of these issuances out there probably have Section 5 problems. They were unregistered securities offerings. But without more, the SEC is going a little bit easy on them, although there's a sweep out there. They're on notice. Everyone out there who's done an ICO is on notice that the SEC could come after them. And whether they will or not is going to be a matter of time and a matter of letting the industry develop a little bit to see which way it develops.
So I was going to add to that, you know, the SEC's sole obligation is not investor protection. Also, you know, we care very much about the development of the marketplace. I was at a conference recently in New York City, and there were 4 very intelligent young millennials on the panel, all Americans. One lived in Switzerland, another one lived in Singapore, another one lived in Hong Kong. The other one, I'm not sure where he lived, but it wasn't the United States. And they were advocating the exodus of all ICOs and kind of intellectual capital offshore because of the unreasonableness in their mind of the federal securities laws in the United States. I think that's a big concern. And I think that's something that the regulators need to be concerned with as well. There needs to be compliance with the law, but we need to foster the growth of this dynamic technology that is blockchain.
So I'm not an SEC lawyer, so I'm sorry about that. Don't mean to disappoint you. My experience is in commodities law. So I quite often get a lot of calls from actually fellow attorneys and participants in the space saying, why do I need to talk to you, right? What does the CFTC have anything to do with it? For those of you who had the pleasure or displeasure to deal with the CFTC, it's a kind of a very unique federal agency. The CFTC was really put in place to regulate the futures market, right? So if you watch Trading Places, have anybody seen that movie with Dan Aykroyd and Eddie Murphy? That's a good CFTC movie because they were essentially involved, you know, manipulating prices of oranges. So there are not that many CFTC movies. They're more SEC movies, right? The Wolf of Wall Street, which was about the CFTC. But look, the CFTC wasn't created to regulate blockchain products and services. But in 2015, out of nowhere, the CFTC issued an administrative order through a settlement with a company called Derivabit. And this really took everyone by surprise. And that essentially order, the CFTC said, look, we view virtual currencies as commodities. That was it. And they actually relied on a 1984 case without any other precedent. It was really just one statement. So you're saying, okay, so I'm doing a securities token offering, or I'm doing an ICO outside of the US. How does this affect me, right? So the moment you have a security, the CFTC really doesn't apply, generally doesn't apply, unless you have a secondary utility token that may potentially come into the CFTC purview, but I'm not going to even discuss that at this point, right? The reality is anytime you are, if you're not registering a security token, and if you're doing it outside of the US, but you have a US participant, well, there's the SEC and there's also the CFTC. And the CFTC, since 2015, has been fairly vocal in the space. And there's been really, a slew of actions, enforcement actions just in the past few months that have established very, very interesting precedent. And they're not going after the big boys, the big guys. They're actually going after kind of the boiler room operators who essentially said, hey, we could manage your crypto, we could manage your utility tokens, you could say, and because you're managing it, you failed to register as a futures commission merchant, or you failed to register as a commodity trading advisor. If you go back to 2 years ago, they had a case against Bitfinex that was doing business with U.S. residents out of the BVI, and they said that they failed to register as an FCM. So the CFTC has been actually quite vocal, right? And the CFTC takes a bit of a different approach than the SEC. Not to say that it's a better approach, but they've been always a principle-based regulator. So their view has always been, and I've had meetings with commissioners for close to a decade, and their view is, look, read our rules. If you think it applies, then you got to consent. If not, we'll see in court, right? So you always have to think about whether or not the offering that you do, to the extent that it's not a security, because then it wouldn't be applicable, is a commodity and falls into the CFTC.
So I think with the developing industry here, we need to unpack what an ICO is a bit. Maybe it's force of habit in the way that we normally raise capital. But I really view the industry currently, especially in the United States, as having 5 distinct lanes. There's 5 types of tokens, essentially, that you could offer in the United States, and I think that plays well elsewhere. The first one would be a security token, and we've heard quite a bit all day today about what that would be. The next would be a commodity token. The third would be a virtual currency, Bitcoin, that sort of thing. The fourth lane is a combination or all of the first 3. And the fifth lane is really a none of the above. And when we start to break it down into those 5 lanes, I think we have more bandwidth and a clearer picture of what laws might apply. So we have the SEC in the first lane, we have the CFTC in the second lane, we have the Department of Treasury and FinCEN in the third lane. We have all 3 potentially in the fourth lane, and maybe no one in the fifth lane. So I think that that term utility token doesn't do us a whole lot of justice. Just because something has utility doesn't make it not a security, doesn't make it not a commodity, and doesn't make it not a virtual currency. So when we take a step back and we see it sort of this way, I think you can see why certain projects go to certain jurisdictions and why the Caymans and British Virgin Islands are really hot right now for the virtual currency type offerings. And you see Hong Kong and Gibraltar and Malta for the more security commodity-esque type coins.
That's yes, quite a variety of different points of view on the regulatory issues surrounding ICOs. And I want to pick up a bit on something that Scott mentioned earlier, which is the international dimension. Because these ICOs being inherently global, the international dimension has always been central. And now with ICO markets overseas booming, while in the United States they're quite problematic, it's even more a consideration than ever. And it's, once again, a very complicated patchwork around the world. When you look at it. South Korea, which is one of the most crypto-focused countries in the world, was, along with China, the first to ban ICOs entirely. And the trend that Scott talked about of Americans going overseas has happened there. I know that, for example, when Hyundai, a subsidiary of Hyundai, wanted to conduct an ICO for a blockchain project of theirs, they went to Zug, Switzerland. I believe that there were a number of possibly members of the founding family of Hyundai who relocated to Zug, Switzerland and decided to do their ICO through a Swiss subsidiary. In China, they had a ban on ICOs, and cryptocurrency exchanges are heavily scrutinized, yet the exchanges still operate. At the other end, you have a number of jurisdictions which are moving ahead quite decisively in attracting this business. Switzerland's been mentioned many times already. Singapore, Hong Kong, they are certainly seen as crypto-friendly in the scale. And then you have smaller jurisdictions like Gibraltar or perhaps Malta or Bermuda, which are all moving forward with highly crypto-friendly laws and regulations. And all this creates a problem for the United States in terms of competitiveness. The United States is certainly not at the probably South Korea or China level of restrictiveness, but it's certainly at a higher level of restrictiveness than most others. And perhaps Scott can first pick up on this and talk about some of the picture in the US and abroad and some of the most important considerations to keep in mind.
Sure. So just looking at the news the last few days, we see China prosecuting what they term to be a Ponzi scheme in China. Singapore warning exchanges if they're selling securities as opposed to, I assume, utilities. There's regulation everywhere, and regulators everywhere are trying to get their arms around this. You have to understand one thing. When you see state regulators get involved, you can't assume that they're acting in conjunction with the SEC. The SEC is the federal regulator. NASA, which is the organization which links together all the states, basically all the states have their own miniature SECs, which enforce the state, it's called the state blue sky laws, announced recently, of course, the sweep that they're undertaking, the SEC is undertaking sweeps as well. And this raises a lot of concern, and it raises concern that I think we need to take very seriously, because we don't want our youngest, brightest, smartest, most innovative speakers moving overseas. But there is a contrary argument. And the contrary argument is, what is going to make this industry mainstream? What is going to make this industry have billion-dollar companies? Two words: institutional investors. Because once you have institutions invest in ICOs or blockchain technology, it's a game changer. What is off-stream becomes mainstream. And what becomes small business becomes huge business. So when you think about that, what will drive institutional investors to invest? Compliance with the laws and predictability. And that's one of the strongest arguments that I could think of why we should be honoring the securities laws that are in place.
So I just wanted to touch on something a little bit contrary to to Scott's view, in that it's not good we have this mass exodus, which it really isn't. Obviously, in terms of remittance of funds, we are going to end up seeing a lot of dollars that could be held in U.S. bank accounts go abroad and be held in abroad bank accounts. However, at the end of the day, the question to me is, will people want to geofence and exclude U.S. markets altogether, including exchanges, issuers? To me, the answer is no. I'm hard-pressed to think that T0 is going to come out and then all of a sudden be like, well, we know that a lot of tokens are issued and they are geofencing the U.S. and not allowing U.S. participants, so we might as well not do that so we can list their tokens. I don't think we're going to end up seeing that. So as far as whether or not a lot of these technologies will actually come to the United States, or rather these operations, I think we'll still see that happen. And we're going to kind of strong-arm everyone into complying with U.S. laws at the end of the day. However, to Scott's point, of course, yeah, we're going to see a lot of people move more abroad if we don't take swift action. But other than that, I mean, I do agree, we need institutional investors. The one thing, whenever we talk about institutional investors coming into the space, I always think about, well, what are they going to be investing in? Personally, I don't see them investing in ICOs. I don't see that happening. And I think currently we end up seeing a lot of ICOs with kind of a broken model, or rather a broken revenue model, where they're creating this ecosystem, and they're saying, yeah, eventually these tokens are going to get in the hands of end users instead of these accredited investors. But the platform doesn't really work that way, because if accredited investors or institutional investors are coming in and buying these tokens, and then they're just trading these tokens, or they're coming in and trying to turn a profit, well, when are we actually going to see this platform succeed and see these problems being solved? But I do think institutional money will come in, and we'll start to see them invest in equity in companies that are just trying to put out legitimate blockchain solutions, as opposed to just trying to fundraise with this token and do this ICO. So I think when we do start to see more institutional investors coming in the space, they won't be investing in tokens. I think they'll be investing more in companies, more in their equity.
So I really like Switzerland, just a personal opinion. Aside from a beautiful little country, I really like how FINMA, their main regulator that oversees financial services, has taken their approach towards this industry, and they've done a really great job. I've worked on many different ICOs with Swiss Counsel. I was in Switzerland last month, and they really have the right approach. They really do. I mean, I work with Maltese ICOs, which are not as active, a couple in Gibraltar, but a few in Singapore. But Switzerland, in my opinion, was really the most fair, straightforward process, right? It's if you're offering an asset-based token, don't go to Switzerland. Don't. You're wasting your time, because you would have to issue securities and the Swiss laws. I don't know if that's going to make sense to you. But most of the ICOs that I've seen, they don't want to do offerings in the U.S. because they don't want to be, dealing with the SEC. And I'm not discouraging. I'm just giving an opinion that, oh, look, we've developed a platform and it's a utility token, right? I can't tell you how many of us have probably gotten calls from potential referrals saying, I have a utility token. That's the first thing that everybody says, I have a utility token. But Switzerland has taken a very good approach, and I really like it. They said, look, if you have a European company, it doesn't have to be a Swiss company, preferably a Swiss company, and you apply with Swiss Counsel for no action relief, you essentially provide your white paper, you fill out a very extensive questionnaire, and you submit it to FINMA. If FINMA believes that you have a utility token, they'll give you a no action letter to conduct your ICO in Switzerland. That's great, right? So you actually have a regulator that gives you blessing to do this in there. Now, you're not going to get a bank account. Please don't count on that. So don't waste your time going to Switzerland, because if you're a U.S. resident with a U.S. passport, you can have a very, very difficult time to get a bank account open. But what I really like about their process, and we're talking about competitiveness between the U.S. and other jurisdictions, and I like how the FINMA is just, look, if we're not convinced that you have a utility token and you're just trying to raise money by having an asset token masked as a utility, you're not going to get an no action letter, okay? But it's a fairly straightforward process. There have been so many no action letter requests in Switzerland that my colleagues there say previously it was like 2 to 3 weeks, now it's like 3 to 6 months, right? It's just enormous, right? And they like this business. The Swiss said, look, we like the banks, and the banks inherently have always had a tug of war with the exchanges, right? So we know that in the U.S., the exchanges want this business. On the future side, we've seen, Bitcoin futures. The CFTC has already said that other exchanges are going to probably certify, virtual currency futures contracts, options contracts. On the SEC side, you have a couple of, NASDAQ is obviously getting into this space, and You have a few companies announced they want to, well, you have ATSs obviously there with accredited investors, but Switzerland, what a great process. I mean, if you could convince a regulator and you get a green light, you get the piece of paper that you're doing it there, but obviously don't take any U.S. participants because then you're back here again.
Felix, I have a follow-up question for you.
Sure.
Do you think that there are really any glimmers of hope for anything remotely resembling the Swiss model to exist in maybe islands in the United States? In addition to Switzerland, there are regulatory sandboxes in a variety of countries globally. There have been attempts to create a few state regulatory sandboxes, but those are only very narrowly in one state. There have been
Wyoming,
OCC's national
fintech charter, which
fintech charter idea, which has been now
litigated.
The litigation is finally over because the case has been dismissed. Do you think that there are any prospects for something like that in the U.S. in the near future?
I'm personally not very optimistic, right? Because I mean, we've seen quite a lot of litigation which was lost by the states. So I don't think the states are going to stop there. I think even if we're going to see a fintech charter, NYDFS is pretty aggressive. They like to have their jurisdiction. They've said it in courts. And the reason I'm not optimistic, and look, you're free to disagree, we have way too many regulators. We really do, right? If you go to most European countries, in the UK, you have the UK FCA, right? In Japan, you have the JFSA, and then you have essentially the auditing part, which is KLFB. In South Korea, you have pretty much one regulator. So it's a lot easier to deal with a one-stop shop and to say, what can we do? Here you got to look at the SEC, CFTC, you have to look at FinCEN rules, you have to look at the state blue sky laws. Am I forgetting anything?
State money transmitter.
Money transmitter, that's right. Right. Oh, that's another thing. So money transmission by itself is a bit of a nightmare because, I pretty much have gotten licenses for clients in every single state. There's only one state that doesn't do it, it's the state of Montana. I don't know why, maybe they didn't get around to do it. It used to be South Carolina. And most states technically don't require, it's a very, we would probably have to have a whole day on this. But look, you're right, the money transmission. So yeah, I'm not personally very optimistic.
Add to that Chairman Clayton said just last week that we've managed to build an $18 trillion economy without any new exemptions. His point being, he didn't see one necessary just for this. So, those recent comments make me think that there shouldn't be anything coming down the pike anytime soon.
I listen to all of this, and I sit here like many of you are and dream of my move to Switzerland. Yeah, let me think about it. Okay, good. I had referenced earlier a bunch of young millennial panelists talking about and encouraging the audience at this New York crypto conference to take your fundraising overseas. But what was in the audience was a lot of individuals from foreign countries. Why are you here? Raising capital. United States is different. It's different from the rest of the world. It's a lot bigger than Switzerland. There's a lot of reasons to try to succeed here, especially if you live here. My favorite is, I'm going to raise money in Singapore and run my company out of there, and then you see the person a month later, oh, you're still here. Then a year later, they're still here because they never left. They're pretending. And to me, that's a great way to get in trouble with a securities regulator. But when you think about the SEC, you have to remember, in the securities industry, there was a revolution in regulation. It was called the Jobs Act. It revolutionized ways that you could raise capital under Reg D, Reg A. It formed the new regulation CF, and these are all possibilities for you if you're seeking to raise capital for a ICO for you to consider. Now, they all have problems. Meaning that there's limitations and issues that we need further guidance with respect to going forward with one of them. For example, Reg D, of course, if you sell a token, that's a security under Reg D, it's restricted. It's restricted for a year. There's similar problems with Reg A. Not the same issue, but similar issues. And Reg CF, you could only raise a little bit over $1 million in a 12-month period. So these have problems, but there's been discussions in Congress about raising some of these limits, addressing some of these issues. and trying to help foster and raise capital in the United States.
I think in the meantime, what you're seeing is a bifurcation of the industry. A lot of folks are moving abroad, or at least purporting to move abroad, or they're making the decision to stay here and taking lead from the pronouncements from the regulators over the last couple of years, and for fear of getting sued by them, have decided to step up and follow the regulations. As a U.S. lawyer, that is my advice. You should follow the law. That's, kind of goes without saying. And if you don't, you're taking a huge risk. For the folks who are going overseas, as we just heard, if you're doing that, you actually still need U.S. law advice on how to be overseas. Because if I've got a Singapore company, I'm over there, but you're still living here and you're making your money and you're operating it from here, the SEC will have jurisdiction over you here. And even if you can, at the end of the day, win on some jurisdictional argument, and that's an uphill battle, they will have personal jurisdiction over you here, anywhere in the United States, in the first instance. So you're opening yourself up for a lawsuit. Right at the beginning, you have to decide, am I doing this offshore? And if so, I'm really going to do it offshore, or am I going to stay here and follow the regulations, at least to the extent that the SEC and CFTC have told everyone that those regulations exist?
I think that all of us have touched in various ways on the ways in which the U.S. system is far more complicated than others. That we have a whole range of federal financial regulators, all of whom have to be taken into account in this area. And furthermore, that we have 50 states and also several territories, all of which have a say in the securities laws, and all of which have to be taken into account. And furthermore, that there are 49 states worth of money transfer laws that create issues. And all of these are problems that are, in a way, below the surface of what is normally talked about. There's, of course, been a great deal of attention toward the New York BIP license. That's occupied a great deal of media attention. Arizona has its state regulatory sandbox. Wyoming has had a slew of legislation that is blockchain and cryptocurrency friendly. However, there is a great deal of complication below that in all the various state governments. And that's been further highlighted recently by the recent crypto sweep announced by NASA, but which is itself only the, collection of what states have been doing already for quite a while. I think since December of last year, Texas and Massachusetts, two very different states in many ways, have been very aggressive in pursuing ICO enforcement actions for fraud. I think all of you have touched upon this issue earlier, but do you have any further thoughts about how the complicated nature of the U.S. system may significantly disadvantage us, and in a way it's a built-in defect in the cryptocurrency and blockchain area?
When you talk about the securities laws, the problem, the problem has always been state regulation. When you're complying with federal law and then you want to sell your securities offering, the fact that you may need to have to comply with the laws and rules of 50 states is problematic to capital formation. When you keep in mind that, okay, well, I'm dealing with the state regulators, so there must be a Uniform Securities Act. There is. There's also a second Uniform Securities Act and a third Uniform Securities Act. And some states have adopted the first, some have adopted the second, some have adopted the third, some have adopted none, some have adopted some, but added other provisions. And it's problematic, and you shouldn't believe, now, Chairman Clayton did issue a press release, it's notable, praising the NASA or the state regulatory sweep. But the SEC and NASA don't always agree with each other, and they don't always agree with each other because of one word, preemption. Do you know what preemption is? That means making only the federal law applicable and overruling the state law, essentially. That's a terrible way to explain it, but essentially rendering the state regulatory rules null and void and requiring people only to comply with the federal laws. That is something that is very important. And look, I have, keep in mind, I was a state regulator for 8 years at the New York Attorney General's office, and I could just, see the hexes that some of my former colleagues would throw at me, but it's true. We don't need regulation stateside if we have federal regulations that cover the applicable areas, and that's where the true fix needs to occur. Now, of course, the states should keep their anti-fraud laws because, again, why is everybody taking all these aggressive actions? Because they want to protect investors. State anti-fraud laws make perfect sense with respect to them and the states bringing actions to accomplish that person, but to raise additional hurdles through state regulation, which inhibit the capital formation process, doesn't help our country.
Very briefly, I think that just to follow up on that, it's a very good point. It's easy to obey all 50 state laws when that law is don't commit fraud in the purchase or sale of securities. You're like, okay, I got to do that on the national level. I'm good for all 50 states too. But the blockchain industry is introducing a lot of new, more subtle issues that the states haven't had a chance to grapple with yet. The SEC and CFTC are grappling with them in different ways and finding different beginnings and ends to their stated authority. All 50 states are now doing the same thing, and they seem to be going in opposite ways. So you've got the Arizona Sandbox Initiative, you've got some pro-blockchain laws in Wyoming, and those are nice, and I appreciate the efforts of the people who are doing that. But it doesn't matter if Wyoming is the most crypto-friendly jurisdiction in the entire world if the only people you can sell to are other Wyoming residents. I'm originally from the West, and I love Wyoming, but there aren't enough there to have a big capital raise. If you can't go across state borders, it's going to have a lot of trouble. For that reason, I really think that the SEC and CFTC need to step up and have clearer guidelines and issue those guidelines to the states in the new issues, the new areas that are coming up. Some of the states may disagree and say, well, we would like to take things a different way, but in our system, the federal government rules are going to preempt the state rules. Sorry to your former colleagues in New York State, but I mean that's just the way it has to be. Otherwise, you're dealing with 51 sets of regulations rather than just one, and it is a real disadvantage.
So I completely agree. I mean, I'm very, very optimistic about seeing a Reg ICO sometime, a bit on the nose, but hey. And although I do take kind of a different opinion about all the states also getting in and, passing their own laws, I think it makes sense because if, 50 years down the road, every company is a blockchain company because blockchain's revolutionary, and that's what we'll see, right, guys? But if, hypothetically that actually occurs, then we'll end up seeing, potentially a bunch, even more tokens, and maybe just intrastate offerings might become a thing down the road. And it's better to be prepared now to deal with these quote unquote intrastate offerings, in one state. And to have those laws in place, because at that point you're not invoking federal laws. So I think it makes sense, but I do definitely think we'll see state preemption in the future Reg ICO.
So I'm going to make a very bold statement. I think the states are killing fintech. They're completely killing it. I think that the SEC and the CFTC, as well with FDIC and OCC, are really dropping the ball on this. They really are, okay? Because why do you need to comply with state laws for products and services that are freely movable in interstate commerce, right? I mean, that's kind of not how the founding fathers created the system, right? The federalist system. But at the end of the day, I understand why the state of Wyoming is trying to be crypto friendly, but let's be very frank. How many of you guys have gone to the state of Wyoming, right? And is it really going to be driving business to the state of Wyoming, or is it more of a PR stunt, right? Because at the end of the day, if you have a business incorporated in the state of Wyoming, but you have clients in the state of New York, well, the New York Division of Financial Services will be knocking on your door, right? So you're not really solving the problem. So it's very, very disappointing that, and it's also very political, right? So I deal a lot with Texas Department of Banking. Texas, obviously, is, aside from New York, California, Florida is a very, very big state. And I'll give you an example, right? So there's an individual who's in the very high ranks in Department of Banking who is not very bright, and she really doesn't understand financial services products. Why am I being so harsh on her? Because she really doesn't want to educate herself. She's been a regulator for 20 plus years. 20 plus years. So she's still in her mid-90s mentality, right? And anytime you mention anything, and when it comes to any new innovative product, and actually, lending products, consumer lending products, let's not even talk about crypto. She doesn't want to hear about it, right? Because she thinks that they're bad, they're evil. The Texas residents will be defrauded by these evil companies that are trying to come in and create new apps. So going back to what I said from the beginning, the states really, unfortunately, can't get their shit together and really kind of collaborate and say, look, why are we fighting all these different fronts? Why are we fighting the federal government? Don't we want to create jobs in these states? I mean, tell me how many jobs the New York bid license, which in my opinion is a joke. There are 5 licenses granted to big companies. I had an associate who left my firm to work on the bid license drafting because he thought this is going to be the next big thing. Well, it's not, because you know how many companies operate or have clients in the state of New York and are not licensed with a bid license? So what's the purpose, right?
Great point. My only additional thought here is then, given that regulatory framework, how is a business to navigate it? And I think we need to come up with some new business models and funding models and kind of separate out those two. So businesses might try to look at the more traditional Reg D, Reg A+, Reg S exemptions, maybe even start looking at doing a true IPO for their equity, but then try to understand what it is that they wanted to try to tokenize. And often I'm hearing projects of it's something akin to credit card points or a loyalty program or a website subscription. And I don't hear a whole lot of folks saying that those are securities currently. Right, and I think just by tokenizing them, that one change wouldn't make them necessarily securities. So separate out your equity model from what it is that you're trying to tokenize, why you're trying to motivate your customer base with this token. I think there's a path there, sort of a 2-track look at things.
That's a huge, I know, just really quickly, that's a huge point. So many people have been coming to me saying, I've got this great business model, I want to raise money by selling tokens, and I say, stop, separate those. You've got a great business, that's wonderful. You want to raise money, wonderful. Can you raise the money without going an ICO route and risking the ire of the SEC? Can you just raise money the normal way that you ordinarily would, and then use that money to build your great blockchain-based business without the regulatory threats? That's a better way to go for the most part if you're going to stay here and do it here.
So respectively, I've had that conversation. We all have, right? Because that's the right way to go about it. But I'm always met with the same answer. Yeah, I can do that, but then I won't make $50 million overnight. So I'd rather just do it this way and hire you to tell me how to do that and make this work. And I mean, often is the case where it really just won't work. Tokenization in itself, it doesn't make you a security. But tokenization and then the facts around that tokenization will. So if you start limiting, there's a cap on the number of these tokens, and these are supposed to be rewards points or a loyalty program. Well, suddenly you end up with this limited supply, and it's price-driven, and it's a variable price that's supposed to be subject to market demand and supply, i.e. not our efforts. Well, what's going to end up happening with that token? We need liquidity suddenly. Well, now we need to slap it up on an exchange. Now this starts to look a lot more like a security. But agreed, I think there's the direct-to-consumer model that you can do where it is traditionally like a royalty program, a rewards program, and it's, hey, you can come buy 500 tokens on my website in perpetuity. There's no limit. These it's $30 for 500 tokens, and this is what you can do with these tokens. But obviously, you're not going to end up with that huge raise that everyone's really itching for, the monkey, it's that monkey on their back, man. So it's problematic. Nobody really wants to do it. But I agree. It's a great approach.
It's the safest. It's probably the most
Yeah,
conservative route that I
is,
can
for
offer.
sure.
Yeah.
Man, ask a bunch of lawyers how to do something. What a bummer.
And Robert, just to jump in, we've got about a few quick minutes left. I'm not sure if you want to do any questions or if you have a few points you want to wrap up on. We could do about 5 more minutes. Thank you so much.
I promised a discussion of anti-money laundering, which we have not even gotten to. I'll go through that very quickly. Questions. Yes, anti-money laundering is one of the elephants in the room in the cryptocurrency and ICO space. It has been obviously a concern for a long time. However, there's been a lack of really much input from FinCEN and the other regulators about it. There's been talk already about the 2013 virtual currency guidance that FinCEN issued and the 2015 enforcement action against Ripple. In this space, those are ancient. The entire rise of cryptocurrencies and ICOs has been accompanied by silence, really, from FinCEN. And there's been a great deal of discussion of the FinCEN letter, including here, but it's overlooked that letter, when you look at it, is not actually from FinCEN. It's a letter from the Treasury Department, a congressional liaison to Congress. It barely addresses ICOs at all and didn't really say very much. In fact, what it amounted to was that FinCEN will defer to the primary regulators, the SEC and CFTC, in the area of AML issues regarding ICOs. Essentially, they don't want to create a complicated situation where you have multiple regulators and multiple voices. All that they will really be dealing with are the cases where there are tokens issued and it doesn't fall into the categories of ICOs that they'll be regulated by either of those. And in those instances, they will be regulated as MSBs and money transmitters. And I think that there hasn't been a discussion yet about what that really means. And that has to be looked at because the system set up by the Bank Secrecy Act is supposed to be very flexible. As mentioned earlier, the Bank Secrecy Act dates back to the 1970s. And the last time that it was significantly revised was in 2001 with the USA Patriot Act. And the system set up after 2001 only establishes very general guidelines on what is required. There are 4 basic pillars that have to be implemented, which are intended to be very flexible and tailored to the institution. So the question of what will be the AML requirements around ICOs and cryptocurrency exchanges, that's a complicated question that the people in the industry should be answering. They should be going to FinCEN and with the answers, because this is a complicated question, and at FinCEN they won't necessarily have the answers. I think there's probably a lot of criticism of them for not knowing enough about this space. Well, that creates the opportunity to inform them and shape what they will eventually do. This is very much like the point that was made in the previous panel of needing to go to the SEC with a regulation, and that being the best way to get what you want. That's probably all we have time for to discuss anti-money laundering. And unless anyone has any further points about it, then I think we can go to questions.
Okay, I'm coming up front to the right. Just want to try to capture the audio, so thank you for your patience.
How's it going? Thanks for the presentation, it was great. Kind of just a small 2-part question. So it sounds like the categorization of utility tokens don't really ring true with the panelists. But with that, is there any pathway do you guys see right now for a U.S. company raising from accredited investors in the U.S. with a platform already up for usage of the token to raise in the U.S.? Is that even a possibility within your minds right now? And then also on top of that, I like how you brought up the equity point, because I think it's going to go towards that as well, where investors are going to get equity and also tokens. So with that, is just offering accredited investors equity and then also saying, hey, by the way, like we're doing an exchange, say, with equity in this exchange, we'll give you our token, which gives you for free. They'll give you 50% off trading fees. Is that a way around current regulations as well.
You got anything?
I mean, I wouldn't say it's a way around, but yeah, you still have to comply with the securities laws.
And just to kind of touch on it, right? So what I'm understanding you're asking is not necessarily, this would be a security token, right? And so, I mean, I don't really see it. There's no real purpose to selling to accredited investors if it's not a security. Because again, if this is a product, then why do you have to protect the investor? Because there's no investor, right? So it needs to really look, it needs to quack like a duck. It needs to be a product. And if you're kind of doing this dual model, like you just said, equity, and then we'll also, slap on some utility tokens on top of that. Well, at the end of the day, you're putting utility tokens, quote unquote, non-security tokens. I think we all agree that's a better term. Right. You're putting non-securities in the hands of an investor. And that economic reality of that whole transaction is at some point, whether it was just a part of the deal or the whole deal itself, an investor is paid for that non-security token, and it's still in the hands of an investor. So at that point, it's still going to be considered a security. So it doesn't, that model, as much as I would love to say works, to me, I don't think it really works.
Yeah, I was just going to add Reg D is the answer to your question, because in the mind of an enforcement attorney, there isn't any such thing as a utility token. If you want to have a utility token separated from your offering, I mean your capital raise, that's the best way how to do it. But how do you do it in a way that complies with the federal securities laws? We could use a little bit more guidance with respect to that. So I used to say when I spoke on panels, I used to say when your lawyer, because lawyers have ethical responsibilities. Everybody up here is a lawyer, and we have ethical responsibilities. When your lawyer tells you how that your securities offering, that your token offering is a utility token, have them put it in writing. Unfortunately, since that time, I've seen a number of legal opinions where lawyers do opine, United States lawyers do opine that it's a utility token in this environment. So that has led to quite a backlash by the SEC, not just against people who want to raise ICOs and other issuers, but also against lawyers. For the first time that I could ever remember, the SEC actually threatened the securities bar for not being responsible with respect to its recommendations. So the starting point is, you want to have a utility token, I'd love to help you design one, but we have to separate it from your capital raise.
Mm-hmm. Okay, question in the back here.
Hi, so I heard you talking about going the traditional fundraising route and avoiding an ICO as a way of dealing with the securities regulatory problem. But if ultimately you're putting tokens out there to be mined to fuel the blockchain that you're operating, and it's going to be exchanged with users on your platform, and the exchange rate is going to vary from time to time, are you not still left with other regulatory problems that y'all have mentioned, be it the CFTC calling it a commodity or with the FTC or whatever? So, just a question about what other concerns you see, even if you successfully navigate that one issue.
Yes. It's just what Nima said. It's one thing to separate them and say we'll have a plain vanilla equity raise that has nothing to do with ICOs. It's just a traditional Reg A or Reg D offering. And then we will separately have a token environment. But if you take that token environment and create a tradable token and put it on an exchange, you're effectively creating a security out of it anyway. So the question that I ask folks is, do you need that tradable token for your business? If you do, then you have to figure out how to structure that, and maybe there isn't a way to do it short of calling it a security, acting like it's a security, and issuing it like it's a security under Reg A or Reg D. But I've talked to a lot of people who don't. I mean, they get into the space, they've got a great business idea, everyone's talking about blockchain and tokens, and it's cool, so they think, I want to do a token offering. When you get down to it, they don't actually have to do a token offering. They have a blockchain-based idea, and that's great, but you don't need to make something that's this tradable thing that's going to get you in trouble. I'm not trying to tell people how to run their business or not run their business. That's fundamentally not what I do. But I think all of us up here, if you came to us and said, this is the structure I want, we'll tell you these are the regulations, this is how you can follow the regulations. And if you can't do it this way, is there a different way that you can do it that won't get you in trouble? Because if you don't come to these guys to structure it the right way, then you are going to get in trouble, and you're going to have to be coming to me later when the SEC sues.
Apologize for a very quick follow-up, and this may be an ignorant question, but if the token's not tradable, then what is the incentive for the miners and the node operators to go and do the work on the ledger?
I mean, you're starting with your own conclusion, the idea that you want a tradable token. And just to take a step back, what is your blockchain business about? Is it about creating, if your blockchain business is about creating a mineable or tradable token, then you're heading into securities. But what are the use cases of blockchain? If you think, intellectual property rights are this really complicated thing and it's hard to get everyone on the same page with what they are, let's try to take this, put it on a blockchain so we can automatically have perfect information across the network for that. That's a really interesting, good use case for blockchain. You don't need a tradable equity token or anything remotely like it. If your problem is, we heard from one of the other panels, old city files, like in the real estate business, you've got all of these city planning documents spread across all sorts of different agencies. It would be great if we could take all of that, digitize it, spread it across a network so that if somebody buys a property or buys a section of the property, a mezz equity piece, then everyone will know who has it and where the money's flows should go. Another great use case for blockchain, you don't need an ICO, you don't need equity tokens, tradable, anything. So, it's easy to get carried away into the new world and the new ecosystems, but it's vitally important to ask the fundamental business questions. What am I trying to do, and how can I do that without getting sued by the regulators?
So I did want to actually mention one thing. It sounds like one of the problems that you're kind of alluding to is that, if we have a blockchain, we need decentralization because we need mining, we need someone to validate. If we don't have the validation, then we don't have a trustless system. It becomes centralized, and all of a sudden, we're back to square one. So in order to do that, one thing I think is often overlooked is you don't need to create you don't need to use these tokens for fundraising. You can still have, for example, Ethereum. These tokens can transfer. You can still sell ERC20 tokens direct to consumer as a product. It just doesn't need to be tied to your fundraise. But agreed, I mean, there's an inherent problem there. I'm not saying we need to get rid of blockchain. I'm not saying we need to get rid of decentralization. I'm just saying use the tools in this current landscape right now that are at your disposal to actually launch a blockchain company. And I'm not saying there aren't going to be problems down the road, because what if you end up launching on a blockchain and that blockchain ends up being considered a security? But obviously, to me, the solution there is, hey, let's try and actually make cryptocurrency a commodity. Anyone who's trading in it needs to actually be licensed as a money services business, as a money transmitter. And then what you can do, if that's just currency and you're selling a product online and you need that currency to work, for your system to work, well, then now you can come to our platform, you can buy our tokens, or you can just use your regular Ether on our platform. Because remember, if you just need things recorded on the blockchain, well, here's our smart contracts, attach them and trade them.
Great, and we have time for one final question.
Hi. Just to add, there's a fifth AML pillar now that has to be complied with for beneficial ownership that went into effect two weeks ago on May 11th. Apart from that, what are your thoughts on consumer protection, and where does that kind of fit into this? Because we haven't heard anything from the CFPB, but if you're selling direct to consumer, is there a thought on this kind of ecosystem having a consumer protection and complaints aspect built into it from a compliance perspective?
Yeah, I mean, if you're selling direct to consumer, it's literally no different than me going online right now and buying something. I mean, there's not money laundering there. I won't be able to go to an exchange and dump these tokens. Well, there would be a company there that would be responsible. There would be a responsible party. I'm not saying create a decentralized company and a product. I mean, you can leverage blockchain, again, without having to use it as a capital raise. And you don't, if you create a token, you can just sell those tokens as a product in perpetuity without a cap, without a need for liquidity, because if anyone needs more of these tokens, once they're consumed, i.e. then burned, you know, in theory, well, now I need more tokens. Okay, I'll just go buy another set of 500 tokens from this website.
Excellent. Unfortunately, that is all the time that we have for this panel. Thank you all so much, and thank you, Robert Kim, for moderating.